All right, I guess we'll get started. Yes, you are all muted. We're on a webinar format, so we'll get started since it's 1:30, and I think we'll have a packed day today. Welcome, everybody. Good afternoon. My name is Eric Hauge. I'm the Executive Director of Homeline, and you're joining us today, February 10th, Wednesday, February 10th at 1:30 in the afternoon for another one of Homeline's regularly scheduled COVID-19 tenant landlord webinars that we've been doing since about mid-April of last year. Again, just like you mentioned, just like I mentioned, this is a webinar format, so you're automatically muted. And if you do have questions or comments, please submit them over the Q&A system over Zoom, or you can send any comments or questions in the chat. Today, we are going to be joined by a couple of guest speakers, legal aid attorneys Catherine Pock and John Buda from, Catherine is from Legal Services of Northwest Minnesota, and John is from Southern Minnesota Regional Legal Services. And we'll get to them shortly after we do a brief intro and a brief update on the current status of the eviction suspensions. Just a reminder about what Homeline is. We are a statewide nonprofit organization. We provide free legal and free and confidential legal advice to renters throughout the state in 4 languages: English, Spanish, Somali, and Hmong. And we've advised over 260,000 renters since we opened. There's our tenant hotline contact information and language-specific lines, as well as how you can reach us on our website and submit a question to an attorney via email. Again, we've been doing these since last April on a regular basis. And in a moment, once Mike gets started, I'm going to put a number of links in the chat so you can access some of our COVID-19 resources on our website, which include some FAQs, as well as recordings of all the previous seminars. But just before we get started, and I'll also put a link to this in the chat, registration for our next seminar. It'll be 2 weeks from today, Wednesday the 24th, another 90-minute webinar beginning in the afternoon at 1:30. And we're excited to be joined by a couple guest speakers 2 weeks from today. The subject will be Minnesota's legislative priorities in response to COVID-19 rental issues. And we're going to be joined by 2 of leaders in the Minnesota House of Representatives, Representative Alice Hausman, DFLer from District 66A, who is the chair of the House Housing, Finance, and Policy Committee, as well as the Republican lead on that committee, Representative Tama Tice, again, a Republican from District 14A. She's the Republican lead on the Housing, Finance, and Policy Committee. So we'll again do a brief update on that week on what's going on with the suspension, but then we're going to kind of hand it over and hear from these legislative leaders about what the legislature is talking about policy-wise on the eviction suspension and other related matters. And we'll also have time for questions, both legal questions and if you have questions about your legislative issues. Okay, so with that, I'm going to hand it over to Homeline's Managing Attorney and Hotline Director, Mike Vra. And just again, a reminder, we're doing a quick overview. And then if you do have questions, we did get some questions submitted in advance, but we're happy to take questions at the end of the presentation today. So feel free to submit them via the Zoom Q&A system. Thank you.
Thanks, Eric. And I saw one quick question in the Q&A that I'll just answer out loud here. Somebody asking if we're applying for CLE credits. Those are credits that lawyers need to get continuing legal education credits. Yes, we are applying for CLE credits for today's presentation, which we traditionally do when we have lawyer guests on. We did that for last session, and I think we got approved for the credits, the one that we had with Kim Tennyson a couple of weeks ago already. And Eric might be able to find and post the CLE code for that one. It's not the code for this one, though. We have yet to apply, but we will be applying for CLE credits for today. All right, so I'm going to start by talking briefly about the Minnesota moratorium on evictions. And then our guest speakers are going to cover some of the other topics that we normally speak in the introductory area. And then we'll get on to the questions, where you get to ask these attorneys that know greater Minnesota better than we do. and they're going to be offering their expertise in that arena. But we're going to start, as we always do, by talking about the current state of the eviction moratorium in Minnesota. This, as we have said since the beginning of, well, not the beginning, but the beginning of when we started doing these things in April, is hurdle number one for any landlords that is thinking about filing an eviction against a tenant for non-payment of rent, which is most evictions in Minnesota, 9 out of 10 plus evictions in Minnesota has historically been for non-payment of rent. When can a landlord file an eviction for non-payment of rent is sort of the overarching question that we've had to grapple with since the pandemic began. And as mentioned, hurdle number one is the state moratorium on evictions. And so right now, where we're at today is we're 2 days away from the end of the current peacetime emergency. So the peacetime emergency is declaration is something that the governor has the power to do in Minnesota when there's a peacetime emergency, which the pandemic clearly has been, and grants the governor very broad powers in that peacetime emergency. The peacetime emergency is limited in a couple of ways. First, it's limited in time. It can only last for 30 days. And then the governor has to renew and say, I'm going to do another peacetime emergency. So I think we're going into the 11th emergency on Friday if the governor renews it, which I have not yet heard. Declaration from the governor's office usually comes a couple days before. Maybe it'll happen during our presentation, not sure. But anyhow, the 12th of February is when the 30 days that we're under currently expires. So at that point, the governor could renew the peacetime emergency, which I think we're expecting, but you never know until it actually happens. The legislature could decide to end the peacetime emergency if they so chose, the state legislature, but both chambers of the Minnesota legislature would have to vote to end the peacetime emergency. That's how it's designed under the statute that pre-existed COVID-19 by decades. There have been several votes, 6 or 7 votes since the peacetime emergency was declared. And in the Minnesota Senate, which is controlled by Republicans, they have the majority there. Every time there's been a vote, the Senate has voted to end the peacetime emergency. However, the Minnesota House, which is controlled by Democrats, the DFL party, has voted not to end the peacetime emergency. The governor's obviously a Democrat, Governor Walz. And so it seems like there's something of a stalemate at the legislative level to end the peacetime emergency. At least there has been so far. So there's really 3 ways, I think, that the peacetime emergency ends. The governor stops doing it, stops renewing it. The legislature votes to end it. Again, you'd need to convince the House, which would be the real challenge because controlled by the same party as the governor. Or a court would end the peacetime emergency. So the peacetime emergency, just to be clear, is not just about evictions. It affects a lot of other things. We've all seen on the news or in the newspaper, on social media, where we hear about dials being turned up or turned back, whether a restaurant can be open, can it be fully open, can it be half open, 25% seating, can a salon be open, can a church have churchgoers present, can we have sporting events, that sort of thing, can schools be open? All those decisions, which really are more declarations than anything else, are based and sourced in that peacetime emergency power that the governor has. The eviction moratorium is a specific rule that the governor passed. It's its own executive order, although it refers in time to the peacetime emergency, basically saying that as long as the peacetime emergency goes on, this eviction moratorium stays in place. Now, I guess that the governor or the legislature could end the eviction moratorium in theory. Certainly the governor could. But the other way it could happen is if a court said, nope, this isn't constitutional somehow, the eviction moratorium or the peacetime emergency, I suppose. So we're going to end that here. Now, has a court heard that yet? Yes, a court has heard that argument, in fact, in federal district court. And the decision was issued on New Year's Eve, actually, Heights versus Waltz, which was issued by a Trump appointee from 2018. The Landlord group, who had challenged the governor's power to have this eviction moratorium, asserted all kinds of constitutional arguments. No due process. This was a taking. There were some First Amendment arguments as well. Contracts clause, supremacy clause. I think supremacy clause was in there. Anyhow, the federal district court said, no, that doesn't really hold up. We got a pandemic, and that's going to be the reason that this is in place. And you're not actually having your property taken from you. You still have a right to file an eviction eventually. You still have a claim for the rent being due. The governor's order does specifically not declare any kind of rent cancellation, rent strike, rent holiday. Rent is still due under the governor's order. And as I've mentioned, this is the first hurdle a landlord has to get past if they're thinking about filing a non-payment of rent eviction. Now, there are some exceptions built into the governor's order. If the tenant is seriously endangering others on the property, if the tenant has caused significant property damage, if the tenant has violated a statute about drugs, no illegal drugs, no illegal guns, no prostitution, no stolen property in the premises, that would be a reason as well. And the last exception would be if the owner of the property or their family member has a need to move in and is planning to move in within 7 days of the tenant leaving. Those are really the exceptions that we have. So a landlord trying to evict for somebody having an unauthorized pet, or the boyfriend or the girlfriend has moved in, an unauthorized occupant, not really allowed under the governor's order. And so evictions have been severely limited over the last 11 months now, frankly. And we're not exactly sure when the state moratorium will end. Okay, so next, I think we're going to hear from Katie. I'm sorry, Catherine. Do you want to go ahead and put your face up on the screen? Thank you. Is it okay for me to call you Katie in this informal setting? I've known Katie for a long time. Actually, she volunteered in our office while she was in law school and started to work with us as well. And then she went on to legal aid once she got done with school. But Katie works you're based in Alexandria, correct? Are you in your office in Alexandria today?
Yes, I am.
Okay, great. For Legal Services of Northwest Minnesota, can you say a little bit about what you do? I know it's not just housing, but then what you're seeing with housing work as well.
Yeah, so like Mike said, my name is Katie Pock. I'm an attorney with Legal Services of Northwest Minnesota in Alexandria. Legal Services of Northwest Minnesota provides civil legal services to low-income individuals across 22 counties in northern Minnesota. So it's not just housing, it's family, consumer, basically most civil legal issues. We have offices in Alexandria, Moorhead, and Bemidji, and I work in the Alex office. Since this webinar has been focused on outstate Minnesota housing law, what I'm going to do is just talk a little bit about what I see in housing law and how that differs between the cities versus outstate from a practitioner standpoint, both pre-pandemic, during the pandemic, and post-pandemic. So I want to start with some pre-pandemic things that I think are of note. One of the biggest differences I've seen between outstate Minnesota and the cities in housing law is people's familiarity with housing court. You see this from lawyers, landlords, judges, everyone. In the cities, there are specific housing courts, and they have housing law referees who primarily do housing law. You also have firms that specialize in housing law or who have a chunk of their practice focused on housing law. And you have a lot of professional landlords and management companies in the cities. Outstate's a little different. In my area, the 22 county area, we don't have specific housing courts. I do think there is a specific housing court in Rochester, but most places in outstate Minnesota don't have specific housing court. They may have 1 or 2 or 3 judges who just do general practice. They cover civil issues, family law issues, criminal law issues. And so that means when you're going to housing court in outstate Minnesota, you're likely going to get a judge who's not super familiar with housing law, particularly the more technical or procedural aspects. And even when you do have a judge that's familiar with housing law, there's likely only going to be one in the jurisdiction. And if that judge is removed, then you're stuck with a judge who doesn't know a lot about housing law. So one of the things that we really have to do out here is educate judges, landlords, attorneys. I like to do written answers in eviction cases because it makes it easy to cite statutes so judges know what I'm talking about. But we do represent low income individuals. So we generally have an IFP, so we don't have to pay for that. So if you're representing someone who doesn't have an IFP, you may want to orally answer. But even then, you probably want to have the statute that says that you can answer at the hearing with you, because some judges are going to say, well, why didn't you file an answer? So just knowing that no one out here is quite as familiar with housing law as some of the people in the cities is really important to know. And that's the same thing with landlords. We have a lot of landlords that are smaller operations where they'll own like a house or a duplex or maybe a couple houses. That's not to say there aren't some big management companies and apartment complexes, but there are a lot of smaller landlords, and they may not do a lot of evictions. They may have one tenant, it may be a long-term tenant. So again, having a rule or a statute and knowing that people may not be experts in housing law would be really important. It's also important to note that with smaller towns and smaller landlords, you sometimes see a more personal connection when you're dealing with tenants and landlords. They may know the tenant, they may know the tenant's family. So that's important to note when negotiating or talking about these things. Another big difference we see in outstate Minnesota is how calendaring is done. In the metro, like I said, you have housing court. So you may have a full block in the morning of initial appearances for evictions. Out here, you may not have an eviction for 2 months or 3 months in a court. So you don't have a specific housing court. In some of the smaller jurisdictions, you may not have an initial appearance. You may show up for that first hearing, and instead of continuing it out, like happens a lot in housing court, you may just have to have a hearing. You know, if there's only one judge in that county and they're only there once or twice a week, they may just want to set the hearing that day. So you always have to be prepared for the full hearing that day. The other thing is there can be additional scheduling issues. So, you know, we'll have an initial appearance and a hearing might be set out further than what the statute says, because you have one judge and the judge has a 2-week jury trial or has a criminal calendar and then 2 family law trials. And so things might be set out. So that's important to know. It's actually helpful a lot of times when you're trying to negotiate if you have some additional time between the first hearing and the second hearing, because it gives people an incentive to come to an agreement. And the final difference I want to talk about pre-pandemic is a little more substantive. In outstate, I think the rules generally are a little more, I'd say loosey-goosey, technical term. And that's true of housing law, family law, everything. I think sometimes the rules aren't followed as strictly as they might be in the cities. And so some of the procedural arguments that you might make or think are strong might not be as successful in outstate Minnesota. One, because, you know, judges might not know about it or understand it. And 2, a lot of times courts will, rather than dismissing a case for a procedural defect, they'll just like continue it for a week to give the landlord a chance to fix it. So that's a big difference that I've noticed. There's also a difference in how the law is interpreted substantively. Some arguments that work in the cities don't work a lot out here. For example, one thing that comes to mind, if there's like a fire in an apartment building, most tenant attorneys in the cities would say, well, the landlord is responsible for finding alternative housing for the tenants that are displaced by that fire. Out here, that argument hasn't been as successful. Not that it shouldn't be made, and I do still think it's a good legal argument, but the law is just interpreted differently out here. And if there's not a clear-cut case or a clear-cut statute, I think sometimes we have a little bit more pro-tenant leaning out here. During the pandemic specifically, we've seen a decrease in evictions like everywhere. But I think there have been proportionately more evictions outstate than in the cities. And John's going to talk specifically about statistics, I think, but I want to talk a little bit about some of those reasons why. Like I discussed, judges aren't as familiar with housing law out here. And so I do think that sometimes evictions that are a bit more of a stretch under the executive order sometimes get set for hearings because judges may not be as familiar with what would qualify and what wouldn't. Additionally, The exception in the executive order that allows a landlord or a landlord's family member to move in is used a lot out here. I've seen it in most of the evictions our office has seen during the pandemic, or at least since the change in the executive order. Sometimes it's in combination with like property damage or illegal activity, but I think it makes more sense out here. When you have a lot of smaller landlords who might own a duplex or a house, it makes more sense that they're going to move in versus a big management company that owns, 1,000 rental units. It doesn't really make sense that they are having a family member move in. So we see that a lot out here, and we have seen that a lot out here. And finally, I just want to mention since the pandemic has started, there's been a real issue with people finding housing in outstate. I think there's always been an issue with affordable housing out here, but particularly since there's no evictions, people aren't moving very much. There's been a real problem with tenants being able to find housing if they are trying to move or if there is a successful eviction. Finally, I just want to talk a little post-pandemic. No one really knows what's going to happen. One of my colleagues likes to say that trying to figure out what it's going to look like when this eviction moratorium ends is like trying to find a needle in a haystack during a blizzard while blindfolded, because there's so many unknowns. We don't know when the executive order is going to end. We don't know if there's going to be additional guidance from the governor, from the legislature. We don't know if there's going to be additional funding for renters or landlords. So it's really hard to figure that out. That being said, I do anticipate there being a difference in how evictions are done in the cities and outstate. I think the fact that we have smaller landlords who might own a house or a duplex is going to really change whether or not evictions are filed versus these big management companies. Because if you have 300 people who are behind on rent, you might not want to evict them all because you might have trouble getting 300 people into housing. Whereas if you have one tenant who's behind on rent, you might think about evicting them because it's going to be pretty easy to find someone who needs a house. So I think that that's going to make a difference. I also think with that small town individual connection, sometimes things are more personal. So I think that's going to make a difference as well. And finally, I do know that, courts are preparing for this wave of evictions. We don't know how many there are going to be. And I think John's going to talk more about predictions, but courts out here are preparing. No one knows exactly what's going to happen, but I do think there's talk of senior judges helping. And there's also talk of doing a more housing style type court calendar out here. For the smaller counties and the smaller judicial districts, it might look like several counties sharing a housing court calendar or a whole judicial district sharing a housing court calendar via Zoom, but trying to prepare for that wave, doing a more, Minneapolis style housing court calendar, being able to have an attorney there staffing it to see if there's defenses, if it's contested, that kind of thing, I think will be helpful. So there is talk of that, but again, no one really knows what's going to happen because it's a different time. What a time to be alive. So that's all I have right now. I think we're handing it over to John maybe, and I will be back for questions.
Yeah, we'll see you in 10 minutes or so, Katie. Thank you. All right, so John, I guess I should ask you the same question I asked Katie. Is it okay for me to call you John, or is it Jonathan, or some longer version?
As you can see from the slide, I am a John with an H. So as long as you can pronounce the H, the H is silent, but we'll know it if you can pronounce that.
So don't pronounce the H. Got it. There's a good note to keep. So John is an attorney working with SMRLS, Southern Minnesota Regional Legal Services, and are you in Rochester today?
Yep, I'm here in Rochester. I'm actually working out of my house, home office, but the office is here too. And I guess I'll go into that a little bit on the next slide. Actually, for those of you who don't know about SMRLS, as we like to call it, we're founded in 1909, oldest legal aid provider in the state, and we cover 33 counties in southern Minnesota. We have, as I mentioned, the southeast region where I am, out of Rochester, and we serve 11 counties out of there. There's a Metro St. Paul office and also an office out in Mankato that covers the southwest part of the state. And then we have our agricultural worker project out of Fargo that covers Minnesota and North Dakota, I believe. Next slide, please, Eric. And that's a little map, I guess, just to give you an idea where our offices are. And the next slide, I believe, for those of you maybe who are familiar with the the different judicial districts, where I practice is primarily in the 3rd judicial district, which is those 11 counties you see on the slide. That is, as you can see, basically the southeast part of the state. Technically, we cover Goodhue County as well, but this is the area that I'm most familiar with. And I just want to say, actually, Katie did a great job sort of, I think, summarizing some of the major differences between what we see in, greater Minnesota or outstate Minnesota and the metro area as far as courts and how landlord-tenant issues might be treated by the courts. I definitely agree that part of the challenge here is our judicial officers, for the most part, and our judges are handling all kinds of different types of cases, criminal matters, family law matters, other kinds of civil cases. And so they don't see a regular number of housing cases like some of the judges in the metro might see in a housing court. And the one exception that Katie also mentioned was in Rochester, where I am, Olmsted County. Although we don't have a housing court that follows the same housing court rules that the metro courts do, Hennepin and Ramsey County have specific rules that apply in their housing court. We do have, fortunately, a judicial officer who hears primarily the majority of the evictions, and so she's more familiar with the law and more, just because of the repetition, is familiar with the statutes and things. Sorry, next slide, please. So I did volunteer actually to cover some statistics, and that is why I have, I did some homework, put together these slides. But I want to give credit to Larry McDonough, who's an attorney who's done a presentation, I know, with Homeline here, I think a couple months ago or very recently, and also Homeline's staff that put together a report back in 2017, and also more recently, since the pandemic, put together some statistics about evictions, which, just to take a step back, pre-pandemic, from the study that was done in 2017 showed that approximately 16,000 eviction cases in Minnesota. 3/4 of those were in the metro, compared to about 25% in greater Minnesota, which I think roughly corresponds to the population density and probably more the number of rental units in the metro compared to greater Minnesota. And compare that to the first 9 months of the pandemic. You're talking March 2020 to October, which is when Homeline did that follow-up study. You see that, first of all, as Katie had mentioned, a pretty dramatic decrease in the number of evictions across the state, which you would expect. But maybe what was a little surprising at the time, but for the reasons that Katie and I have discussed already a little bit, you see that the proportion of evictions in greater Minnesota actually went up as a proportion of overall state. So it's more of a 50-50 ratio for that period. And I guess the next slide just sort of gives you the visual. It's really close to 50-50 there. And that's something that's a little unusual, but could be because of the familiarity that everyone has with these types of cases in the metro, and particularly the landlord attorneys who might, see a case, or a client of theirs comes to them with a case that's on the edges of whether it would apply, whether the executive order or an exception would apply to it. They might hold off on filing that case, whereas in greater Minnesota, an attorney might not be familiar, or maybe a mom and pop landlord might not be aware of the executive order exceptions, or they might just be more willing to file one that's on the cusp of whether it's included or not. And similarly with the judicial officers and the judges reviewing those complaints and eviction actions in greater Minnesota, they might be more likely to allow something to proceed if it's on the cusp versus the metro area. I think you see more cases that aren't accepted or aren't allowed to proceed because courts are finding that the moratorium applies. If you go to the next slide, I think this is a breakdown of that same data that Homeline put together and showing broken out by county. And I put a little arrow next to Olmsted because based on what Homeline discovered throughout this process, it actually looks like Olmsted County did not follow the trend of the other counties in greater Minnesota. So there was actually less than you would expect evictions, given the other counties. The percentage of evictions per number of rental units was a little lower in Olmsted, and potentially that's because, like I said before, there's a judicial officer who's more regularly handling housing cases here, and I think the bar here as well would be more reluctant to move forward with an eviction action. So that does provide some support for that theory. Next slide. And so going to 2019, the year before the pandemic, of course, you could see that we had about 1,000 evictions in the 3rd Judicial District, and we broke down some stats by county. Olmsted, which is by far the largest, had actually more than 377 is a little low. Technically, we had more than that, but a number of little more than 100 of those were expunged. So this 377 does not include evictions that were expunged, meaning the court record was sealed or deleted, basically. But still, you could see quite a number of evictions in Winona, Moore, and Steele, around 100 in 2019. Go to the next slide, please. 2020, the year of the pandemic, there was only, I guess you could say, 303 evictions in the 3rd, and this includes January, February, March, really before the executive order went into effect. And you can see we broke it down by county again, a pretty dramatic decrease in the number of evictions that are filed during 2020 compared to 2019. So the concern now is, as Mike did a good job pointing out, 90% of evictions are for non-payment of rent. What happens to those evictions that weren't filed in 2020 because they couldn't because of the moratorium? When the moratorium is lifted, and if you go to the next slide, actually, I think, oh, this is a nice little bar graph that I put together. The pink obviously is 2020 and the blue is 2019, shows you that pretty dramatic decrease in evictions. But that gap there that I'm talking about is something that we're expecting to see, sort of that eviction tsunami or tidal wave that will come when the moratorium is lifted. And on the next slide, I think we have some estimates of what we expect. And again, I give Larry McDonough the credit for putting together estimates. I know he studied a lot of different sources, including census data and unemployment, to try to get a handle on how many people are actually behind on their rent. And we might expect we'll get evictions, an eviction notice once the landlord is allowed to do that. We think a conservative estimate would be 10 times the pre-pandemic level for the first month after the moratorium is lifted. And so how that looks in raw numbers is statewide, we're talking 13,000 evictions in the first month. Hennepin County, 5,000. Olmsted County, 310, which compared to 5,000 doesn't sound like a lot, but for a county that is used to seeing maybe 300 in a year, that's a lot of evictions to handle in 1 month. And if you break it out, to a calendar for the court, you got to go schedule 77 eviction hearings in 1 week on top of all the other hearings that are going on. And if you want to have an attorney there, like me or some of my other colleagues that might be there, you know, that's going to be hard for us to represent 77 people in a week. And then that, not to mention our other counties, Winona, Mower, Steele County, those are going to be pretty substantial volume of cases. So even if they can consolidate calendars, we're going to be seeing a large number of evictions. So what's the plan for that? I could go to the next slide, Eric. One of the things that we started before the pandemic in Olmsted County was something called the Eviction Prevention Project. And we partnered with Legal Assistance of Olmsted County, Lutheran Social Services, the Olmsted County Financial Services, and also had volunteers from Mayo Clinic Legal Department and the IBM Legal Department helping to represent tenants who are getting evicted in Olmsted County. Like I said, there was actually 514 evictions in 2019 and 137 were expunged as a result of settlements that we reached. We represented about 250 tenants that year as a part of the clinic. So you know, we couldn't represent everybody sometimes if they're not eligible for our services, or maybe, you know, they didn't show up to court, you know, we wouldn't be able to represent them, but the rest of them, we would try to work something out. Most of the cases we did settle, a couple of them went to trial. And like I said, we got a lot of them expunged, and that's helpful for, of course, the tenants who are looking for housing in the future, that they don't have that eviction on their record. So we're hoping to be able to implement that again once the moratorium is lifted. And we're also, next slide, please, hoping to expand into those 4 most populous counties. We're going to try to do a similar program there. And since we have the Zoom capabilities, I think that'll make it more possible to appear and collaborate among the different counties and the different social services agencies that help and provide financial assistance to the tenants that are behind on rent. We also worked with the attorneys that represent landlords to agree to a 3-week continuance between the initial hearing and the trial that will allow us to hopefully find some resources for the tenants to be able to get caught up on the rent, or at least work out some kind of repayment agreement, so that the landlords can get their rent and avoid the eviction. And of course, we also, you know, don't want to necessarily wait until an eviction is filed before we help people. If you know of tenants who are behind on the rent, they can call our diversion project number, which is there on the screen. Actually goes to our Rochester office, and we can get some information and maybe connect the tenant with some resources so that they can get caught up on their rent before they end up getting an eviction. So that's a basic outline of sort of where we're doing. I think Mike had also asked me to just touch on a couple of arguments that might be relevant. I think actually I could answer one of the questions I saw that went in the Q&A too on the next slide, if you will. The CARES Act is a federal statute that probably you remember. I know Homeline did a whole presentation about the CARES Act, probably at the closer to, you know, beginning of last year, when it was first passed. But there are some parts and protections for tenants in the CARES Act that are still in effect. And so one of those is, and not every apartment is going to be covered by the CARES Act. I guess the first question is the apartment or the unit or the building that the tenant's in covered by the CARES Act? But a lot of them are, and you can see kind of the general categories here on the screen of what would be covered under the CARES Act. And if it is covered, then that means that the landlord cannot evict the tenant for any reason, even a reason that's included in our state eviction moratorium or an exception in the moratorium, still cannot be evicted without getting a 30-day notice. So that's something to keep in mind. Next slide, please. There's also other protections for landlords and owners of properties that have a federally backed mortgage. And if you have requested a forbearance on that mortgage, then there were prohibitions on charging late fees or evicting your tenants during the time that that forbearance was in effect. And so potentially that could still be in effect, because my understanding is the forbearance protections for certain types of federal mortgages has been extended through the end of March. There's also, foreclosure moratorium as well, for people that are worried about foreclosure, that depending on the type of federal loan or mortgage you have, you have protections against foreclosures as well. Next slide, please. And then of course you've got the CDC order. And that's where I know somebody had posted in the chat or the Q&A, whether when the state eviction moratorium ends at some point, would the CDC order be followed? And I guess that depends on when the state moratorium ends, because as of now, the CDC order has only been continued through end of March. So it would have, state moratorium would have to be stopped first, or if the CDC order gets extended beyond that. But if the CDC order was still in effect, it would certainly apply in Minnesota. And technically, as this slide indicates, you would apply the CDC order on a case-by-case basis. So generally speaking, it doesn't apply in most situations here, because the executive order 20-79 provides greater protection. However, in some instances, for example, where a landlord is claiming the family member exception to the executive order, because that type of exemption does not exist under the CDC order, the CDC order could apply in that situation and come in and provide greater protection to the tenant. So it's important to be aware of all of these different, federal and state protections that are out there for tenants. And hopefully, it's just a real high level overview of those. But if you have questions, I guess now is the time to go to it.
Yeah, John, we have one question that came in that's asking specifically about something you have. Eric, if you could go back a couple of slides. This is a question from Aaron, who is asking about the 10 times rate. So I'll just say the question out loud. Can you talk more, this is for John, can you talk more about how you and Larry landed on that 10 times rate of pre-pandemic filings as a conservative estimate for expected filings in the first month of non-payment cases? So she's wondering how, I think these are the numbers she's talking about. How did you get these numbers?
Yeah, so I'm going to defer to Larry on that. Like I said, he did a presentation with Homeline. I think probably he covered this in more detail not too long ago. Mike, I don't know if you know if that was recorded.
Yep.
But I know. Go ahead, Eric.
Oh, Larry is on if you want. He can chat us, or we can have him talk if he wants.
Oh,
but
great.
I don't want to put him on the spot, but I will put the link to the presentation that he did, and he keeps his slides updated, so I'll send a link out in the chat to that as well.
Great. So
as I understand it, though, it was sort of a dividing the annual evictions by 12 and then multiplying it by the number of months that there was an eviction moratorium was in place, is sort of how I've devised it all along, is kind of the most conservative estimate I could make. And I thought it had to be higher than that because unemployment's not the same as it was a year ago. But let me just ask both of you guys a question that is always kind of not bothered me, but it's sort of a thought I've always had about presenting this kind of case in front of a judge where you are pretty sure that you know the law a lot better than the judge, and how you present that to a judge without, I mean, there's a fine line between informing the judge and being condescending. Do you have any tips for practitioners that have actually looked at this and they know the eviction stuff cold before they go in front of the judge, who might have just come out of a murder case and that's where their mind really is, but you need to get them focused in on this sort of thing?
I think it depends on the judge. I mean, most judges that I'm in front of are pretty good about listening to attorney arguments. So if you have the statute, I just cite it. I have a copy if they want to know exactly what it says, I can read it to them. But most of them are pretty good about, they hear so many things out here. They're pretty good about listening to attorney arguments. You know, sometimes I think in housing court, and I've observed housing court and been in housing court in the city, sometimes arguments aren't listened to a lot because they look at the case and they know, because they've seen 100 evictions like that. Whereas out here, I haven't had a lot of judges just, you know, dismiss me without allowing me to make my argument. So I just think, I mean, don't be rude about it, but be prepared to cite a statute and have the statute with you if, you know, if the judge wants you to just straight up read it to them, you can. So.
What advice would you give to a tenant appearing on their own, or a landlord appearing on their own, appearing pro se, as lawyers call it, with that same issue that the tenant or the landlord might have really studied up on this? You got the judge wearing the black robe, sitting up really high, and they got a lot of law books around them. They must know all these laws. How is it that you express, hey, judge, I think there's a statute that really matters here. I'd like you to look at it.
I mean, I'd have the same advice. You know, I tell tenants who are going in by themselves, judges are human beings, and they don't know everything. You know, they've been studying the law for a long time. But if you have a statute, you say, Your Honor, I was looking at this. I think this statute applies. Here's the statute number, and have that. Again, you can find statutes on the revisers. You don't have to be an attorney to find a statute. It's on the revisers website. And so if you've talked to legal aid and maybe you don't, or you've talked to an attorney but don't have representation, or you've looked at it, you can print that out and you can, or write it down and give that to a judge. You know, they're just human beings. They're doing their best.
Sure. Absolutely.
Yeah,
All right.
Mike, sorry, Mike,
Yes.
one thing I would add to that, I guess, you know, one of the things we like as lawyers to point to is precedent, you know, examples of other judges doing something and in how it applies in our particular case in front of us, and asking the judge to do the same thing that the last judge did. But when the challenge in housing is there aren't a lot of precedent that is considered binding, you know, so the Court of Appeals cases that are published are kind of few and far between, and there's a number of unpublished ones that are, you know, technically persuasive but not binding. And then you've got district court determinations that I think Larry and others have done a great job of trying to compile those and have that as a resource. And sometimes we will include those other district court determinations as authority, at least persuasive, to explain to some judges that might not be familiar with an issue that, look, this isn't that unusual, you know, this is something that's been done before, and hopefully that helps to and I think education, like Katie pointed out, is a big part of what we do.
Okay, why don't we take it off the slideshow, Eric? Because now we come to honestly, one of my favorite parts of every week anymore. Well, not every week, but we don't do these every week, but where we answer questions from people, because we never know exactly what people are going to ask us. Although we have some of the questions in advance, so we have some idea what they're asking. And how we've decided to do this is I'm going to ask the questions and I'm going to alternate between Katie and John. If one person wants to jump in, that's fine too. But you're not buzzing it. It's not a game show. There's no prizes. I hope you weren't promised anything or led to believe that if you had the better answers, you'd win something. All right, so Katie, we'll start with you since John just presented. Got a question from Gabrielle, who's a service provider. Again, if you have questions, submit them in the Q&A box. Also great if you let us know what sort of role you have. Are you a landlord? Are you a tenant, social worker, lawyer, judge, whatever? Tell us what your role is, and it helps us frame the answer perspective-wise. From a service provider, Katie, the question is, have any executive orders been revised, specifically charging late fees, increasing rents, or maybe giving a 30-day notice to vacate? So I think this is about the state orders more than anything else.
Yeah, I mean, there was an additional stay of evictions, and then that was replaced with the new executive order that we covered. So there was that change. And I don't know that there's anything specifically regarding late fees or rent increases in executive orders. I know that there is a statute or an executive order about no price gouging that can be kind of applied to increasing rents. But I don't know that there's been anything specifically about rents and executive orders.
Yeah, the price gouging you just mentioned has a 20% cap. So the prices are fixed like a month before the peacetime declaration for essential services, which housing, I think it actually specifically lists housing as one of the things that counts. But yeah, the orders, the last time the executive order on evictions was revised would have been August of last year. And I think we're on the third version now. There was another tweak in the summer times at some point, but there have been no subsequent tweaks. The governor's office indicated at that time they weren't planning on doing any more, that we've thought about all this. This is what we're going to use going forward. And so far, they've been pretty true to that. All right, let's go on to John with a question from Carrie, who sounds like she might be a county staff member of some type. Are you hearing about households owing over 6 months of rent? Is there any game plan to get them back on track? So I think they're asking, it's one thing to owe a month, but what if you owe a mountain of rent? Is it a different status for that person, or how are they treated differently if they are?
Well, I'll answer that the best I can. I guess I forgot to, at the beginning, I meant to kind of give my disclaimer that, some of my answers, these are going to be based on my own personal, opinion. And I can't say for sure that, SMRLS or any other attorney would have the same necessarily opinion on some of these things. So, but in my experience, I have not seen anybody who's 6 months behind, just, hasn't paid anything for 6 months. I'm not saying they're not out there. It's quite possible, but I've seen more people who have had difficulty paying rent, maybe paid partial rent for that period, or paid what they could if the landlord is willing to accept partial payment, and that sometimes can be an issue as well. But maybe Eric, I know you're more familiar with some of the financial resources that are out there. We recently had the CHAPS funding that was supposed to be able to help certain people to get caught up on rent that they were behind, and now I understand we've got hopefully another program that will be unrolled soon by Minnesota Housing to help people get caught up on rent. So those are the types of programs, that I would refer a client like that to.
Yeah, and there's been a couple questions that have come in about, sort of rental assistance, et cetera. So I'll just kind of say the same thing, I think, basically that I said 2 weeks ago, and that is that the federal dollars that were approved at the end of last year, like December 27th or something like that, are $375 million approximately is coming to Minnesota for rental assistance. And I'll throw a link up in the chat to the page on Minnesota Housing. They're the State Department for Housing. They're one of the entities that's receiving a good portion of the dollars and will help. We'll be setting up the administration of that. And there's a page on their website where you can actually sign up for when there's more news on it. I was on a call earlier this morning that had staff from Minnesota Housing and folks from Hennepin County and Minneapolis, who are also two jurisdictions that got funding through that. And they're just still kind of sitting tight, waiting for guidance from the U.S. Department of Treasury on kind of basically exactly what they have to ask in the application. What are the questions they have to ask in the application process? And so they're working on setting up like a centralized payment processing system, an online system, a system that folks can call to apply. Some of the jurisdictions are talking about both a tenant application process and a landlord application process. So that's really all there is to share at this point. And I'll put the link in the chat, but I think it's basically the news is that the money is there, and it's gonna be accessible at some point hopefully within the next month or something. They haven't promised any dates. We do hope, from Homeline's perspective, we do hope that once it is announced and it's up and running, just like we did last year with the chat program, we had some staff from Minnesota Housing come on one of our webinars and share more about it. So we'll plan to do that again.
And I can sort of reply to what John said. We've heard from multiple tenants and many landlords in these speeches of tenants being multiple months behind. I think, John, you're right. Most tenants aren't multiple months behind, but there are tenants that haven't paid since March or even longer before that. The landlord had held off on filing an eviction, and then the pandemic hit, and a guy named Mike just posted that he has quite a few tenants multiple months behind in rent and says over $40,000 worth. So yeah, there's some real piles of debt owed by tenants around the state. Fortunately, it's not as much as we thought. When this all began, there was a real concern that evictions are just going to start and because everybody lost their job, but there was money that came through the first CARES Act, and there's been a subsequent infusion of money. So that's why it's not as bad as it could have been, clearly. But let's go on to some more questions. This one's for you, Katie, from April, a service provider in Greater Minnesota. How can I help someone who's homeless with 5 dogs? Wow. Find a place to live. That's more of a challenge.
I don't have a great answer. I think you just have to, especially in outstate, you probably want to look for a house. I think it would be hard to have 5 dogs in an apartment. And I tell people who have a challenge finding housing for whatever reason, maybe they have evictions on their record, maybe they have a criminal conviction, maybe they have multiple dogs. I like to look for smaller landlords in those kinds of situations where you can develop a rapport with the landlord, explain your situation. I think sometimes those personal bonds really help landlords accept tenants that they normally wouldn't. So I like to look at smaller landlords, but I don't know that there's a great answer. I mean, I don't have a list of places that will accept dogs.
Yeah, I hear you. But look, some landlords love dogs too. So there's going to be a landlord out there that says, yeah, sure, 5 dogs. You can have 6 if you like.
Hey, Mike,
Yeah.
One thing I would add too is, of course, the Fair Housing Act and the Minnesota Human Rights Act requires the landlord to accept animals if they're needed for a disability-related reason. So it's certainly possible that that client has 5 dogs because of a disability, and that, we have seen, believe it or not, in our office more than 5 animals, and a therapist will attest that that's due to disability related reasons. So it's not just as easy as saying you need to find a landlord that will allow it, because it may be that the landlord's required to allow it. So
Fair enough. Good point.
Contact our office if they're in our region. We can discuss that further too.
Okay. Clerical logistical question. Will Homeline be sending out the webinar recording? Yeah, we'll be posting a recording. Eric will. How does that happen, Eric? Do we just post it on our website? Is that what we do? Or does it get sent to the attendees as well?
Yeah, it'll get posted to our website in the next day or so. We'll add the slides too.
Sure.
And that'll be a download there. And everybody who attended today should get a follow-up email from Deb in our office. It'll have a link. And then again, like Mike said, we are applying for CLE credit. We apply sort of basically today, and we'll know within a couple weeks. So that you'll get a follow-up email on that.
Right. Staying with you, Eric, the next 2 questions I'm going to combine into one. They're really about the money. And I know we've talked about this, but I want to make sure that you think that all the parts of that question have been answered. So both Joe and Paul, I think they're both landlords. Is the 25 billion renter assistance funds available in Minnesota yet? 25 billion. How do we apply for it? And then Joe adding, do you see any relief for landlords if this non-payment continues? I think those are tied together.
Yeah, again, I mean, there's not much else to share. I can't remember what the federal number was originally. Maybe it was 25 billion. But the pot that was approved on December 27th, again, 375 million coming to Minnesota. It is getting split between jurisdictions to Minnesota Housing, and then I think 7 county and cities that are of a certain size, as well as some tribes. And so that will be coming out, like we said, and I guess on the other question was, do we see any relief for if the non-payment? I mean, it's hard to estimate if 375 million is enough in Minnesota, and so I think that's a concern, and I think we share that concern. We also share the concern that even if we have 375 million, which is sort of an unprecedented amount for rental assistance in our state, that it's not going to get out fast enough with some sort of eviction ramp off. And so we need to make sure that those are kind of tied together. And then the other thing to say on that, I think, is that I do believe that there's been some efforts even beyond this stuff that was passed in December in Congress to get additional funding beyond that. That's not been approved, I don't think, yet, but there is potential of more to come. But
okay. Yeah. Thanks. New question that was following up on something John just said. Can the number of animals matter for an ESA? Meaning, are 5 dogs really necessary to address the condition the tenant has?
I mean, that's going to be a fact question. I mean, you have to, all the dogs have to be necessary, right? You can't just have, I have depression, so I need a dog and then have 5 of them. They all have to be necessary, but it's going to be based on the fact, and it's going to be based on what the therapist, thinks, or the, whoever.
The medical professional. Got it. Right. Okay, John, this one's for you. This is from Patty, a landlord. The tenant is damaging property and having a lot of disturbance where cops are involved. Is this enough to evict during the moratorium? So again, damaging property and a lot of disturbance.
Well, I think you got to look at the eviction moratorium and the exceptions, and damaging property might get her there. It just depends. It has to be significant damage. And I know we've seen cases where a tenant might have damaged the property, but was able to remedy the damage before the case was heard by the judge. And so the judge declined to evict because the damage had already been fixed.
And it's got to be significant. That word is in there, is in the executive order.
Absolutely true. And then criminal activity, again, could be a basis. Depends on the type of activity, who's actually alleged to be committing that criminal activity. Obviously, if the tenant is a victim of some kind of criminal activity, you wouldn't want to hold them responsible for that. So it really, you have to look at it, I think, more specifically on a case-by-case basis.
Sure.
And I would add, if the cops are being called for like loud music, that's not going to probably fit into the exception, versus if the cops are being called because, someone pointed a gun at someone's head, that might be different. So the cops could be called for non-criminal activity, just like a noise violation, and that I don't think would fit the exceptions.
Okay, Katie, this one's for you. One of the reasons why I've liked doing these webinars is I run a tenant hotline where we listen to tenant issues and stories and questions all day long. But this is the one time we really get to hear directly from landlords, and there's a lot of suffering for landlords out there too. And Lorraine is a landlord. You can feel the frustration in what she wrote here. She wants to get squatters, a word we see thrown around a lot in these webinars. She wants to get squatters out of her unit during COVID when they don't even have a lease. She goes on to say, how do we get a tenant out that has not been paying their rent since way before COVID started? We live in another state, but our property's in Minneapolis. And there's some squatters that are shacked up with this tenant, her words, and no one has a real lease in our property right now. The one guy that hasn't paid in over a year and a half only had a month-to-month lease. We're 18 hours away and have not been able to pay our mortgage in over a year because of these freeloaders and COVID, and can't evict.
I mean, non-payment right now is not a reason to evict. So even if that person had a month-to-month lease, if it continues month-to-month, which it probably does, you can't just evict or give notice to terminate unless it falls within one of these bases: the significantly damaging property, if that's a material violation of the lease, remaining on the property after proper notice that a family member or the landlord is moving in, seriously endangering the safety of other residents, seriously endangering the safety of others on the property, if that's a material violation of the lease, or violating 504B.171, which is some illegal activities. So, if the tenant has people living with them that aren't on the lease, I don't think that that's a basis. The tenant's not paying rent. Again, I don't think that that's a basis right now, unfortunately. So, and I know it's hard because people do have mortgages that they have to pay, and they're probably using tenant funds to do that, but it's just not a basis right now.
Understood. But as I said, this again, it drives home all the time that there's people on both sides of this issue, tenants and landlords, that are trying to cope with the whole world, and it's not easy. All right, John, for you, this is from Eric, not the guy in the other screen, but a different Eric. Can a landlord evict someone for having a political sign in their window that they disagree with? Not really the season for it, although maybe political signs have become year-round things now.
Oh, that's another one where you kind of have to go maybe, because it depends on the type of housing, first of all, that they're in. I'm going to assume maybe Eric's asking about, let's say, a private landlord. And so they might be able to have something in their lease that prohibits certain types of signage now I'm kind of talking non-pandemic times, just theoretical. Of course, during the executive order, the moratorium, having a sign in the window is not going to rise to the level of an exception to the executive order. So I guess the easy answer would be no. But in non-pandemic times, there might be I could think of maybe situation where they could.
I dug into this once, maybe 15 years ago, with a tenant that called. And at the time, the key separator seemed to be if the landlord banned political signs, that wasn't okay. But if they banned all signs, that might be okay. And so I'm not sure if that's still the rule, but I think it probably is. But I would actually check with the ACLU would be the starting point for me on that one.
Well, and of course, whether the First Amendment applies to a private landlord or not is a question, but it could be a lease violation, but would it be enough of a lease violation to even amount to an eviction, even in non-moratorium times? I mean, you still have to show a material violation of the lease in order to get an eviction in Minnesota. So just having a sign in the window, probably not going to get you there.
Over to you, Katie, from Carlton. Have there been issues in outstate Minnesota areas with law enforcement carrying out evictions that should be illegal under the eviction suspensions? I know some law enforcement in some areas have not been very enthusiastic in enforcing other parts of the COVID-19 rules, like restaurant closures. I'm wondering if there are issues like that in Greater Minnesota.
Not that I have been aware of. We have had tenants call who are being evicted or who have been evicted, but there's normally a court order. So a judge said that it was okay to evict during this time. Now, whether I think the judge was correct, might be a different story, but I haven't seen any law enforcement breaking the rules and, executing a writ without a judge's order. So
I get the thrust of the question because it's all in the news these days. So thanks for that answer. John, a landlord asked me today, if the state eviction moratorium ends, then how about the CDC federal eviction moratorium? Will our state follow that moratorium? I know you've already answered this, but it's one of those things we get again and again. So repeating it makes sense.
Exactly. That was the one I was thinking of when I covered that a little bit earlier. But short answer is yes. I mean, as long as the CDC eviction moratorium is in effect, it's going to apply in Minnesota, depending on a case-by-case basis, like I said earlier. So it just kind of depends on the timing of the two, whichever one lives longer. And can I just piggyback on that last question too, and Katie, I agree, I had a similar experience here that I haven't seen law enforcement, carrying out evictions or without the authority, but we have seen a few kind of landlords here and there, and mostly the mom and pops that don't have an attorney are doing what we call kind of like the self-help eviction, where they just change the locks or shut off the utilities because they're trying to get somebody out, and they may or may not realize that that's wrong and technically is a misdemeanor and is a civil violation, which could result in penalties and other fines against them. So just something to keep in mind for landlords out there, that if you aren't aware, you can't just turn off the utilities, even if somebody hasn't paid rent for a year, or you can't just change the locks. You have to go through the court process. There's only one way to lawfully evict somebody, and that's through the court process.
We've seen that too. People getting frustrated and locking tenants out or shutting off utilities. So
sure.
Yeah.
Okay, this one is for
I was going to jump in there really quick and just, it's a good spot to just say that the Attorney General's office, and I'll put the link, they are the enforcement mechanism for the executive order, and they have, since the early days of the suspension, I think, intervened in those situations. In most cases, it's like a phone call or a letter, but I think they did file some cases too.
All right, Katie, I think, by the way, we're doing questions that have been submitted during the presentation now. We're done with the pre-submitted questions that were sent in advance, and so we're on to today's questions, and I think we'll have time to get to all of them. If you still have a question, feel free to add it in and we'll try to get to it. From Dustin, in a single occupancy building, a resident who has 2 additional people living with them, is it possible to evict this person at this time? They're blatantly breaking the lease, and I don't want other residents to think that this behavior is okay.
Same answer. I don't think, I mean, they may be violating the lease, and during normal times, I think you can evict somebody for having a non-authorized occupant living there. But right now that does not fit into one of the exceptions, damage of property, landlord, family member, endangering safety of residents or other people, or the illegal activity. So I don't think that's a basis right now unless there's something else going on.
Okay, on to John. So if I keep my rent paid up, sounds like this is a tenant. If I keep my rent paid up, I'm on a voucher. I assume that's a Section 8 voucher. How would I get food or meds as COVID prevention regarded as additional funding needed versus failing to pay rent and risking the voucher? Or can I only get rent help by jeopardizing my voucher? I think that the question is, which bill should I pay with my limited funds? Almost a strategic question. Which one is the better move to try to qualify for the assistance? Eric, you're welcome to jump in on this too.
I was just I know we've gotten questions in the past because some of the emergency assistance, rent assistance programs, you were not eligible if you had some certain types of subsidized housing, particularly those types that would drop your rent to zero or close to zero if your income. And so I don't know what the rule is going to be for the new program, but I'm not sure. I can't answer that question. I'm just saying I think that's what it's getting at.
John, any thoughts?
I'll just add that, in pre-pandemic times, as a housing attorney, my advice is always, if you got to pick who to pay your landlord first, because you need a roof over your head. And if you get behind on the rent pre-pandemic, of course, that's going to put your housing at risk. Now, maybe the calculation is a little different because you can't be evicted for non-payment right now. And if you need medicine because you have COVID and you need to get better, maybe that's the right call. And financial counseling services are out there in our region. We often refer clients to Lutheran Social Services financial counseling, and they can go over your budget and help figure out, what if there's options and other resources that might be available.
Okay, Katie, this might be a social worker, Georgianne. A client that resides in Dakota County, so just south of the cities, is getting late fees for late rental payment. Is that allowable? Are late fees allowable?
My understanding is generally yes. I mean, you still have to pay rent, and generally late fees are allowable. I know John talked about in his presentation that there is a CARES Act section that prohibits late fees if you're in forbearances on some federally backed multifamily mortgages. So if that's the situation, you might want to contact an attorney. But I think generally speaking, yes, late fees can still be charged. Rent is still supposed to be paid. I understand that there's problems. We just can't have evictions for non-payment.
Yeah, I think that's right. The standard late fee rules apply. It's got to be written. It's got to be in the lease. The late fees do. It can't exceed 8%. These are all state laws that predate COVID-19 by almost a decade now. But late fees are allowable at present under the state moratorium, the CDC moratorium. The late fees are allowable. Wow, I don't think we could have planned this better. John, have you received any court orders holding that the CDC moratorium applies to protect tenants despite Executive Order 2079's property owner family member exception? Seems like a novel legal argument.
No, that's perfect for me. I guess novel in the sense that it is rare, absolutely, because I'm aware of out of our office one example where we raised this argument, and unfortunately, we didn't get a decision one way or the other from the judge because the case settled, which happens, a lot. I do know, and maybe, there might be other cases around the state. If there are, I'm not aware of them. But there are other states that I think have had similar circumstances where the CDC order has been found to apply in situations where the state protections have a gap, maybe not specifically for family members, but some other exceptions. So there is some precedent, again, not necessarily binding, but certainly persuasive that's how the CDC order would work.
So just to summarize it, you're arguing that the CDC order invalidates the family member exception to the executive order in Minnesota?
I think everything else in the CDC order would still have to apply. So, we don't have time to go into all the details
Sure.
on that, but there's an affidavit that the tenant has to complete and some other criteria that has to be met. But you certainly, in some cases, that CDC order would provide greater protection than the state moratorium, which means it could obviate that exception.
Katie, this is for you. Does the size of the county in outstate Minnesota pose transportation challenges to your clients in terms of appearing in court, and have remote hearings made it easier for clients to appear? So maybe you could do it before the pandemic and during the pandemic answer.
Yeah, so transportation is a huge issue out here for services, for court, for everything. I do think, I really like Zoom hearings because I don't have to drive an hour for court or 2 hours for court. I think a lot of clients like Zoom hearings because, again, they don't have to drive and then they don't have that transportation issue. I do think some of our clients don't have internet access. So that has been a problem. So I'm really looking forward to the day where we can have in-person hearings and Zoom hearings. And I hope that we kind of take the best of both worlds there, where if it's easier for clients who are in a county seat to walk over to the courthouse, if they don't have access to the internet, they can do that. Or if it's easier for clients who are far away, they can do Zoom. So I'm hoping we can kind of combine those. But yes, Minnesota outstate transportation problems are huge. And I think Zoom has helped that.
So you're talking about a sort of a hybrid future system where we'd have some people show up in court and maybe my hologram would sit on the witness stand, or how would this work exactly?
I don't get to make the rules, but I think Zoom hearings for anything that doesn't require testimony would be really, really helpful to a lot of people. When you're offering a lot of exhibits and testimony, it gets a little bit harder. But I think even then, if a witness is from far away and needs to appear by Zoom, I think it's in the best interest of using our resources well. And so I hope we keep some of the Zoom hearings, but I do think for some clients, it might be easier to be in the courtroom for a variety of reasons, whether it be lack of internet access, whether it be, some people need interpreters and it's hard for an interpreter over the computer. So I hope we can, once the pandemic is over, keep the best of both worlds.
Well, yeah, I think there's no, you hear about how industries are talking about switching to remote work in the future, maybe permanently. There's no way that courts haven't been forced to experiment, and maybe you're starting to appreciate that, hey, things can be maybe streamlined this way. Maybe we can make things better because we were forced into this. One of the tiny potential upsides from the whole pandemic, I guess, is this realization that we don't always have to do everything in person.
Although I had trouble getting my cat face filter to work today. So
oh, wow. That was
a
solid hour and 15 minutes before somebody brought up the cat video. It's great. John, on to you. What if there's a domestic violence situation where the victim and children were being cared for by the grandfather who owns the property? Then the son, perpetrator, wanted to take the house. Wow, that's so specific.
Well, it is, but and sadly, it's not. This is not really an uncommon type of fact pattern. Maybe not exactly this scenario, but something like this is, welcome to my world, because a lot of my clients unfortunately have these kind of strange circumstances, and unfortunately DV is often a factor, especially nowadays where everybody's kind of cooped up and think that's a big problem. I can't give specific advice to this person, unfortunately, without knowing more detail, but if they're in our region, I would encourage them to contact our hotline, and we could talk about their specific situation, or any, whoever the legal services agency is in their area, I think would want to give them some advice.
And I might also add that, like with the DV situation, it might not just be a housing law answer, right? There might be other answers if there's DV, like criminal answers or order for protection answers or things like that. So I would consult an attorney.
Definitely.
Katie, you get a question from Catherine, but with a C. Please elaborate more on the outright exceptions to evictions and those that are tied to breaches of a lease. I'm a county law librarian, and I field a lot of questions by both landlords and tenants. So she wants to know about the state exceptions to evictions.
So state exceptions are this, and actually I'm going to plug Homeline because they have a really great thing where they say since the August 4th change to the executive order, here's what you can get evicted for. It's on their website. But you can get evicted for significantly damaging property if that is a material violation of the lease, remaining in the property after the landlord's given proper notice that their family member is moving into the property, seriously endangering the safety of other residents, seriously endangering the safety of others on the property if that's a material violation of the lease, and violating 504B171, which is illegal activities, drugs, like possession of drugs or use of drugs, possession of stolen goods, prostitution. I think I'm missing something, but yeah, that's for illegal activities. So those are the exceptions right now under the state order, but it's on Homeline's website. You can also look at the actual executive order, which is 2079, I think.
Yep. When you're trying to find them, it's EO, which is Executive Order 20, which is 2020, and 79 was the 79th order last year. We're into 21, so the new orders, and there's been several already this year, would be EO 21 - whatever. All right. Thank you for the plug too, as well. John, what remedy would you recommend to a landlord when a tenant citing COVID concerns refuses to allow an inspection? So the tenant refuses to allow an inspection under circumstances explicitly allowed by both the lease and the statute.
Well, I think, I guess assuming it is related to COVID concerns, and let's say this tenant, maybe they're immunocompromised or something, then they probably shouldn't have anybody in the unit that would risk giving them the disease. Perhaps they could work something out where they could do a virtual inspection. I know we've had some success with that, where it's like a Zoom call or something, video chat, FaceTime situation. They can walk you through the unit. What do you want to see? If that's appropriate, that would probably be the best.
Okay. Katie, will the rental assistance be available to people in federally assisted or public housing? Maybe that one's for Eric more.
Yeah, I don't really have an answer to that. I mean, I am hoping there's more assistance coming, but I don't know if there will be or who it will be available to.
Right. And the next question in line, Eric, is there assistance funding for landlords that could help the woman with squatters that we heard about earlier? Which was an unpaid, probably month-to-month holdover tenant, I think we decided based on the information we had.
Yeah, I mean, so I think I didn't really answer it, but the first question, what we don't know yet because that program is not entirely set up, but if it's anything like the last one, the answer is no, because folks with certain types of subsidized housing, if their income goes down, then the rent goes down with it, and then the landlord would be getting a good portion of the rent from the housing authority or whatever. But that's not always exactly the truth in all types of programs. So there potentially are gaps there, and that's one thing that I think has Minnesota Housing and other providers have heard from the public quite a bit. And then the second question, I don't know. I mean, again, the thing we're waiting on for that money to get out the door is the Department of Treasury to give guidance to all the states and the entities that got those dollars, like Minnesota Housing. And because they're sitting there waiting to get it out the door, but they don't know what questions have to be in the application. So,
Katie, that wasn't really a question you could answer, so I'm going to give you the next one too. And this is from an attorney named Paul. I am representing an estate in probate, which owns a home. So the estate owns the home. The decedent's girlfriend, that's clearly an attorney writing, the decedent's girlfriend resided in the home with the decedent. She is not paying rent. The personal representative would like to give notice for her to vacate. However, he would like to ask the girlfriend to pay the utilities. Are there any restrictions on eviction in this situation? If she is asked to pay the utilities and does not do so, does this give her a claim that the eviction is for non-payment of rent?
That's complicated. So a residential tenant, under the statutory definition, I'm literally reading this, you should look it up, 504B.001 says that a residential tenant means a person who's occupying a dwelling in a residential building under lease or contract, whether oral or written, that requires payment of money or exchange of services, all other regular occupants of that dwelling unit or resident of a manufactured home park. So it's a pretty liberal definition. I think if someone is paying utilities to stay in a place, they would be considered a tenant. And then you would have to meet one of the exceptions. I don't know what the situation is that she's living there now, if she's a tenant now, but if she's paying utilities, I think she has a great argument that she's a tenant.
All right, John, how can you get a deposit from a private landlord? I think this is a tenant. How can you get a deposit from a private landlord who's not responsive to request? The family moved out 3 months ago. Maybe it's a social worker.
Yeah, that's unfortunately we see that quite a bit. I'm sure you all do at Homeline as well, and put a plug in for Homeline. There's some sample materials and answer that question, I'm sure, is on your site. But generally speaking, the landlord has 21 days or 3 weeks to return the security deposit, or if they're going to keep it or part of it, they have to send a letter to the tenant saying why they're not returning it. And then if there's a dispute over that, or if you don't get the letter at all, is what maybe happened here, then I think first step for the tenant or the family is to write a letter to their old landlord, say, hey, we didn't get the security deposit back. I'm not sure if you overlooked that or what, try to work it out. See if, and now unfortunately, if they're non-responsive to that, then you got to take them to court, and you can sue them in conciliation court under the statute that discusses security deposits. And there's potentially extra damages if it was done in bad faith. And I think you could certainly get some advice, from an attorney from Homeline or one of the legal services offices for more specifics on how to do that.
What have you heard about conciliation courts wait time in your areas versus what it was before the pandemic?
It's
either one.
It's a long wait. I mean, it was always kind of a wait, especially in some of the more like Olmsted County, it was always a pretty long wait after you filed something. I think some of the smaller counties, you might get a case heard quicker, but even it's just a low priority, unfortunately for the courts. They're dealing with trying to handle criminal cases and trying to figure out what to do with all the other types of cases. So unfortunately that I know I have a client who filed a conciliation court case over a deposit issue in October, I think he filed, and the hearing was just this week is coming up. So about 6 months, and that's a smaller county. So that's actually probably a pretty short time compared to some of those other counties though.
So let's see, who are we up to now? I'm sorry, I lost it. Are we on you, Katie? Your turn? Okay. Gene is asking a series of questions. Gene's a case manager working to advocate with a client. Not really rental stuff though. Can they mandate mortgage assistance and owner payments be paid at the same time or sale of a house? I'm not going to follow up with the rest of the question because I think this is really kind of a home ownership based specific question, I think.
Yeah, I don't know the answer to that.
Where would you tell somebody if they called you up? What kind of resources would you send them to, if any?
Law help probably might have some information. You can also talk to a private attorney. We don't deal with a ton of buying a house issues.
I'd also probably recommend the Minnesota Home Ownership Center as at least a starting point. If they can't help, they probably know somebody, if there is an agency out there that would help with that, that would. They've been around for a long time and cover the entire state, as I understand it. All right, John, this is the last question I see, unless there's some more buried in the chat portion that weren't put in the Q&A. And hey, this is a fun one. Landlord is the writer of the question. Is marijuana an illegal drug in Minnesota? How would I present evidence of marijuana use? Well,
I guess I think the first part, depends on what you mean by illegal. Under state law, marijuana, a small amount, is considered a petty misdemeanor, which is defined under criminal law as not a crime, a petty misdemeanor. So in other words, a small amount of marijuana would not be a criminal activity under state law. Under federal law, it's still a controlled substance, so that's potentially a problem. How to present evidence? That you could go to law school for 3 years and still not know.
Well, no, what wins a case for a landlord traditionally on a marijuana claim, I guess? What do you think? What kind of evidence would be typically admitted in a victorious case for marijuana by a landlord? Is it enough to say I'm wandering by and I smelled marijuana outside in the hallway? Do you think?
Right. Probably not, unless your tenant admits it. I mean, I think it's,
sure.
you gotta, it's it's a preponderance of the evidence standard, so it's not as high as a criminal case. It's more likely than not that the landlord is telling the truth, and so sometimes you might, but just smelling it in the hallway, no. Pictures maybe of the tenant, using it in front of you on a video maybe and admitting it, that's, the other edge of the spectrum. So you just have to, depends on what the situation is.
We've also seen people be successful if, another tenant might come testify that they used in front of them, or if, the police were called and the police found something, there's a police report, that might also.
Right. Okay. Do you guys have 2 or 3 more minutes to stick around, or you both need to jump off? I don't want to keep you longer if you can't.
I got a few.
Okay. I got a couple last questions and then we'll get to the end here. All right. So for Katie, what about dangerous but not yet damaging lease violations? So the tenant insists on using space heaters in the unit is an example given. Would that qualify under any of the exceptions in your mind for the eviction moratorium?
No, I understand that we're thinking maybe the space heater could cause fire, probably, right? That's why we're thinking it's a danger. But I don't think that that is a danger to themselves or other tenants unless if a space heater started a fire and the tenant continued to use the same space heater, maybe, if it started a small fire and clearly wasn't something that could be used, but I don't think using a space heater is a basis.
Okay. John, if they are not on the lease, can people be designated as trespassing illegally? So I think they're talking about an unauthorized occupant. Could you have somebody trespassed off property now instead of filing an eviction?
So this is kind of one I'm always kind of interested in, and people get confused a lot on this, unfortunately, but and it's hard to tell from the question, what exactly the situation is, but if there's someone there who's a tenant and they invite a guest, it could be a violation of the lease if it's going to be an unauthorized occupant and they're going to stay for more than 2 weeks or whatever the lease says as a guest. But it's not trespassing because they're inviting them. The tenant is inviting, and the tenant has the right to have any guests that they want. The landlord sometimes thinks, well, if I trespass this person, then my tenant's not going to be able to invite them anymore. And unfortunately, that's not the way it works, or at least it shouldn't work that way. If law enforcement is called and the landlord says, I've trespassed this person, the tenant should be able, and the person who's being accused of trespassing should be able to explain, I'm a guest of the tenant and I have permission to be here, so it's not trespassing. And there's good case law in Minnesota that would be dismissed unfortunately, if law enforcement continued to press and say that was trespassing, it wouldn't stand up in criminal court. But there is a lot of confusion about that, and if you have such people in those situations, it's hard to say, well, just tell law enforcement this and they should do the right thing, because sometimes it's in the heat of the moment. It's always better to follow the instructions of law enforcement if they're telling you to leave, if you don't want to get arrested, and then follow up with an attorney later, and we can work with the landlord to explain, what the real law is on that.
Katie, you're going to get the last question sent your way from Gabrielle, a landlord. I have a tenant many months behind in rent. I've attempted many times to get a payment plan in place. Is this harassment? Is it harassment to keep asking for the rent right now as a landlord?
No, rent is still due, and I think you can still ask for it within reason. If you're calling someone 300 times a day to try and get rent, or like standing outside their door at 2 a.m. asking for rent, yes, that's not okay probably, but like within reason, asking the tenant for rent, I think is fine, because there still is an obligation to pay rent right now, even if you can't evict on that basis.
Okay, well, Eric, I think we're going to end the question section now. Thank you both, John and Katie, for not only sharing your thoughts up front, but answering questions, a lot of which you hadn't seen until I said them. And that's never an easy thing to do in a format like this, but I really appreciate it. It's been very informative for us.
Greatly appreciate both of you being on, and want to thank everybody who joined us and sent in questions. I'll just remind folks, I did put it in the chat, but I'll put up on the screen before we say goodbye. Just a reminder, if you want to, you can go ahead and visit our website to register for the seminar. Actually, sorry, it's not up on our website yet, but the link in the chat will get you to the registration, and it'll be up on our website in a little bit. But for the seminar in 2 weeks, where we'll have a couple state legislators on, Representative Alice Hausman and Representative Thomas Tice.
And sorry, Eric, before you go, I did just see this in the chat. They said to throw in a plug for landlords to refer tenants to community action agencies. And I would highly recommend, if your tenants are behind, tell them to go to their community action, see if FHPAP has funds. Sorry.
Agreed. Yeah, no, thank you. So yeah, and that's what our session is in 2 weeks. And again, we're hearing that the possibility of the new rental assistance program getting set up within the next month or so. So that means sometime in March, we'll hopefully have a session with some folks from Minnesota Housing and maybe other agencies that are administering that program, since we got a lot of questions about it. So thanks for joining us today. Appreciate you all being here. Goodbye.